Returnable motion. Extension when it is expiring. Expire when? 31st of July. When it is expiring. Property as in the hotel. Who is appealing for the other side? Who is appealing? Yes. The contest order by you taking advantage of that, it would be they are not. The receiver is now violating the order. But it's appealing as the item number 117. Yeah, we indicated that in the mention is I think I'll update it. And I find can applications, but in respect of modification of those orders, section 5 of the other side. If you come, bring him. Bring him. So another matter. That is what? What is the issue? Which corporation? Who is appealing? Then there is no urgency. Then there is no urgency. For mentioning for urgency or senior advocate. So what is that?
No, I'm not a senior.
Who is appealing for the
Now the panel has changed. Cornish Cooper.
This has he come?
No, he keeps it one way or the Today was the best thing. I was also drawing the lordship's attention to the other matter.
If you can bring, can be taken.
Otherwise, Monday. I can't bring minute. I can't bring minute.
Why?
I will try. We can talk about this trial.
Yes. Under the sleep.
The item number 19 in minus is
Yes.
Regarding section 10 of 6, I find two applications before one to DRT.
Date is there.
But
Please appeal for the date.
the advocate for the bank, I had to serve the
Which bank? Who is appealing for? Let me see. Let it be called out.
Other matter.
Let me see. It's not appearing in the list.
The first The code of justice matter is in the list, but unfortunately the matter which are also. Kindly keep
So
it.
you are also appearing.
No,
You are not appearing. 96.
no, I am not so blessed.
You will not be appearing in 96.
No. Let me see.
I just know that you are appearing.
No, other matter will make appear on one. I'll give
Because
the
the other side has come today.
Most likely.
He has come that can be taken up.
In the supplement.
Yes. If your other side has come, you can. Give me the number. For us.
Number 16. Every logic kind is mentioned item 106. On my monthly.
Yes.
I bring one application.
What is the urgency?
The urgency is that I have come up against an.
There is a KVA. There is no KVA.
But it can be taken out at 2 p.m.
What is the urgency?
The urgency is that we have come up against the refusal of injunction. The
Refusal of injunction. What provision?
On the ground.
Under what provision? Order 39. It's an appellable order.
But it's part.
Maybe it's an appellable order.
I take it at 2 p.m. Well,
I can take it up now. If you have the copy, I can take it up now.
But 2 p.m. Bring the judgments also.
Appeal is maintainable against an refusal to pass an.
Again, it's part of refusal. I'll bring
Yes. Please also bring the other judgment. It says appeal is filed, revision does not like. Please bring both sides because nowadays obviously people have said that you have to
discuss both sides.
Yes. So you have to.
Well, I'm coming back at
judgments which are against you also.
I'll come back at 2 p.m.
Yes. 156.
156 of
Of the
the
month is 2 p.m.
I thought the other side is not.
It's not come. Then Mr. Vadaji, Monday might be a difficult because
Tuesday are the fifth is the fifth.
where is the please give us sleep. Please give us sleep mentioning that it was Mr. Vadaji, please give us sleep mentioning that it was today.
The other one. The
Yes.
court matter.
Yes, good matter.
I'm mentioning the other matter as Mr. Chocolate.
That's the difficult because so many matters, Mr. Vadaji, that's difficult. I cannot keep track of it. That is the
Court matter when I'm giving the sleep. But when the matter which
court matter, the other side has not come. That will be give the sleep mentioning that it was due to appear today. Uta, yes.
I have made an application on 38th the landed either on 2 p.m. I won't be taking up any so much. The people also say that I'm new and not there is a position which is on my head. I don't know 90 and the cover use some I don't know.
Give us sleep. Yes. Yes.
I don't know. One thing
Yes, what do you want?
you believe in there and
No KVM is there. Please wait. If it is not taken up, hold on serially. If it does not reach, please mention it one. If it does not reach serially. Want to move this? You want to move this matter? Yes, yes, please, wait, let me call out serially. If it does not reach by one, please mention. I will taking up, yes.
And then has not found
Entry model will expire on Monday. Please hand over the slip for extension of entry model. Have you mentioned extension of entry model? Yes. Monthly list 457.
Can be taken up with the supplementary list of because
What is the urgency?
urgency is so we have challenged an order.
Is there any caveat?
There's no caveat.
There's no caveat. 457. 456. Number is comment. Please wait after this it will be taken. After this.
I don't know similarly of this is other that is also
You are there.
kindly
Please let
give the
me-
matter
let
taken
me
over
see.
kindly give
No.
the matter
If you not no fixing on another thing, you can take your chance today. Yes.
I just indicate that there is another unlisted motion. The urgency is
Unlisted motion.
unlisted, but there is no caveat.
Unlisted. You are saying the item number in your saying.
This is let's see on frequency of 2020.
Why it is not listed?
But we are trying to put the standard on the bench saying the urgency of people could not be. I just indicate what is the
It will appear in the list.
but today the matter is that my evidence would be
That is correct.
but there is no caveat. We can just pick the but at least not in June.
When it appear, it will be appearing in the monthly.
1994 of Malar's statements
Yes.
without caveat. Some others.
Okay, please wait. Let me see how I can.
Malar till 1 o'clock and we have already
Yes.
solved. We have already solved the other side.
But if the other side is
I
not
understand.
clear today, you have to have another.
That's why I said if we get on Tuesday the supplementary list, I will
Please
make
hand over the slip. Please hand over the slip. Yeah, please.
wait for this correction.
Corrections, please hand over. Yes, on the list.
Number one.
Point. Pass over. Next.
Number three. Number four. at another height. But these
Caveat is there to support. No caveat. Yes, sir.
dummy.
Hearing aid petition was filed. Yes.
Evidence for the difficulty of the PW1. That there is evidence and there are some other action happening by the application. What are what is the PW1? The court said that it is the duty of the plaintiff in this case, and my lord, for that, my lord, I may not be permitted. Take order that you pass.
What is the date of the order?
Date of the order. What is?
Thank you, sir. What is this item? Item number 6. Support your appearing item number 6. Item number 8. Talk about next.
Yeah.
Yes. Expeditious hearing. Why Monday? You want the amendment application to be disposed of expeditiously.
Junction application may be heard out as quickly as possible.
Yes. Dispose of the amendment application. Well, what is the next date, please?
Next date is
22nd of May. What was the next date, please?
thereafter is somewhere around
October. For hearing of the order 6-17.
Various other applications are also pending. He had filed an amendment application seeking that
You want the amendment application filed by whom?
by the plaintiffs.
But the plaintiff. You want the amendment to be hard out fast.
First and deadline may be given so that the injunction may be also heard out. It is a suit of 2023 lawsuit. It
application. This application.
One intelligence solution it was 20 August 2026 report of the
24th of August. The next day. Of August 26th.
like item number 8.
Yes. This is the rate. On which date? Twenty-sixth of August 2025. Where is that date? Where is that order? 26th of August 2025.
Yeah, carrying power of the PW1 is great, but I said it was there is a strong objection by stating that though the carrying power of the PW1 was big, but she does not usually carry weight as per the purpose of the topic. Other than something that she on the first day of proceedings and dated 5/6/24, 5/6/24, larger than the defendant has thoroughly examined the PW1 and the next day on 26/8/25 issued last date in this on 5th of June was examined and the next date was 5th of 26/8. This court concluded that what happened on 26/8 that are not mistake. Asked whether it is that it was examined on 5th of June. And the next date was 26/8. This was concluded and discharged the PW.
Where is that order? 26th of August 2025.
In the petition, it has been stated.
Where have you come up with such a belated period? This is Chakravarti order was passed 19th of June 2026. Yes, 19th of January 2026. Why have you come in the month of July? Why you waited for so long? And there was another date in the meantime for evidence of the PW2.
And certified copy has been applied for on 17th of March.
So certified copy was applied on 17th of March. Why?
And it is
And it was delivered on 7th of May. So you also delayed in applying for the certified copy. The 2nd of December has been fixed for evidence of PW2. 22nd of December has been fixed for evidence of PW2. So Chakravarti, can you serve and come back on Monday? Why? Today your court is open, civil court. You can serve upon your counterpart. Please come on Monday. So this is not civil court. Ramna. Make a Xerox copy, please. What is this? Expeditious hearing of what?
Whole shoe. The matter is stuck till today. On PCRD.
Old shoe. How much old?
Yes, they have filed the contribution of 8,025 and several it has been passed for SRD. Last date was 7. Still on SRD and states by pending.
There is no, except this suit, no other suit of 2025 is pending. Because this court, this cover, no other suit is pending. All suits disposed of.
But my.
I am asking you, you are saying this is a very old suit of 2025. Except this suit, all other suits have been disposed of.
To you to complete the trial of injunction declaration file, the state of matter is stuck on SRD.
SRD.
Yes.
Then, madam, it's more difficult. If the SRD has not been completed, please complete the service. You are the plaintiff.
I'm the plaintiff.
So please complete the service first.
We have done all the things, my lord. We have done all the past. But the matter still
that's-
stuck with.
Where is the order sheet? Where is the order sheet?
I have annexed
You have not annexed the order sheet also.
but no order has been passed in, my lord.
SRD, you are saying no order has been passed.
I have only
This
the
application
standard.
under article.
Item number 10.
Madam, you are appealing in person. Yes. Bengali, yes. Speak the microphone. Yes. What is this matter?
Take the order and Chinese
Uh, 20th of May 2026 এর অর্ডারটা চ্যালেঞ্জ করেছেন এই অর্ডারটা আপনি অপোজিট পার্টি এখানে none appears. Yes. Mr. Bhattaji, any caveat is there?
No, blood is for expedition for disposal of the order 617 should add the movie. It has a plain because either the
Mr.
application or
Bhattaji are not entertaining the application expedition hearing moved by senior.
there is a Saturday blood. Only because it's a Saturday.
Then
we
have
have
to,
to come.
then have to dismiss this application.
No, kindly do not. Sir, Prakash, this name may be recorded. But only because it's a Saturday. The regular I could understand.
For any other people, this panel
I
should be given some chance, because also you have a duty, Mr. Bhattaji. That's why you have to come up.
But if your lordship can't sleep, focus on the chief.
No, since you have appeared, it can move. Yes,
At
what is
this
this?
moment, Lord, I do not bother your lordship. It's not only that the
You are the plaintiff.
and the plaintiff. Just for a declaration. I took out an application for an order 617.
At what stage?
Look, the trial had EW1 complete.
So after the commencement of trial.
Commencement of the trial.
So
Now,
it's fixed on 26th of August.
no, before that there were 4 dates. This is the 4th date. And the defendant did not file the written
But written objection has also not been filed. As it appears from the
Yes.
order dated 8th of June.
Yes.
After that has it been filed? What is the instruction?
But it has not been filed.
It has not been filed. On previous dates
So
also time was
I kindly see for the date starting from 13/11/2025, about 2 pages. But 13/11/2025, my client signed for order 617 application. But it was fixed on 9th of January for hearing. Thereafter, Lord, another Lord, the date was given on the basis of Lord, the resolution was there. Thereafter,
on 3 occasions on account of resolution for the
yes,
adjournment.
it was, and but the last one and the previous one on the basis of the adjournment petition of the defendant number one and
This application under Article Yes, next.
Item 12, my lord, I beg to appear on behalf of the petitioner. Uh, my lord, video cannot be. Video
Yes,
is
but
off,
you-
my lord. Kindly allow me to enter.
Yes, yes.
Item 12, I appear on behalf of the petitioner.
Yes.
Yes. I am praying for expeditious disposal, my lord, of the title suit number 2232 of 2022, my lord.
What is the stage of the suit?
My lord, trial is yet to commence, my lord. In this 5th August is the next date for counterclaim, and my lord, 24th August 2026 is the date for Order 6, Rule 17 application hearing, my lord. The plaintiffs from 2023, my lord, kindly see the conduct of the plaintiff. I am appearing on behalf of the defendant as petitioner before your lordship. They are continuously sought for adjournment.
The defendant, you have filed a written statement when?
Sorry, my lord.
You have filed a written statement when?
Yes, I have filed a written statement, my lord. Give me give me time, my lord. I am telling you, your lordship.
The suit has been fixed for ex parte hearing. You have
No,
filed
no, my lord. No, my lord. I have suit has not been fixed for here. Now already, I have filed on 5th August, my lord. Counter claim is fixed. I have duly filed the written statement, my lord, and
when have you
20.
filed- when have you filed the written statement?
Just give me 2 minutes time, my lord. I don't have the physical copy of the brief, my lord. Kindly 2 minutes time. I will address your lordship. Kindly 2 minutes time, my lord. On 28th August 2023, my lord.
But please kindly come to the order dated 31st of March 2026. Date is fixed for ex parte peremptory hearing.
Yes, that was vacated, my lord. That was also vacated. Thereafter, also vacated, my lord.
When it was vacated.
Peremptory hearing was fixed.
You have filed on 31st of March 2026. You have filed a written statement along with the counter claim.
2000 in the year of 2023, my lord. I have filed the written statement already, my lord.
It does not appear from here. Please see the order dated 31st of March. Madam, please look at this. And you have filed an application for vacating the ex parte hearing
Yes,
order.
peremptory. The plaintiff sought for adjournments, my lord. Kindly see the last orders, my lord. Kindly see. I have appear on a regular basis, my lord. Kindly see the last orders since 2023, my lord. Kindly see the order was against the plaintiff, my lord.
2023.
Order, kindly see, my lord.
Where is the order vacating the ex parte hearing? Which order?
23rd November 2023. Kindly see the conduct of the plaintiff, my lord. 23rd November 2023. Kindly see the order of the plaintiff since 23rd November 2023. Thereafter, 9 January 2024. Thereafter, 1st February 2024. Thereafter, 27th February 2024. 27th March 2024. Continuously, they have sought for adjournment. They have prayed for commission. That commission work was order was previous past allowed. Thereafter, the order of the commission was recalled by the learned court below, my lord. Continuously, this is the conduct of the plaintiff, my lord. As per my instruction is, my lord, 5th August is fixed for counterclaim. The plaintiff has not filed any written objection against the counterclaim, and 24th August 2026. Kindly see the order number 41, my lord. My lord, at order 17 March plaintiff's once, my lord, 17th March order. Kindly see, my lord. The plaintiff has once more sought for adjournment. Kindly see the conduct of the 17th March order, my lord.
So your counterclaim is fixed for ex parte hearing.
Yes. My lord, one more indulgence. Entire suit may be disposed of as expeditiously as possible, my lord. Maybe specified type, my lord. It is very much required, my lord. Kindly see the conduct of the plaintiff. I am before your lordship.
Appearing for this.
One more thing, my lord, I want to add, my lord. Extremely sorry, my lord. I don't know 12.
Yes, I know what you want.
My lord, counterclaim is I have already filed the ex parte bracket application, and counterclaim is not been in a ex parte stage.
You have said that it's fixed for parentary hearing.
Parentary hearing, I have already filed the vacating application, and vacating application was, my lord, allowed, my lord, with
Which
the
part
cost of
the spending, it covers
5th August is fixed for counterclaim, my lord. The plaintiff has not filed
counterclaim
any
what?
written
Counterclaim for what?
counterclaim against the suit, my lord,
That I
for
understand.
dismissing, for recover counterclaim for cancelling the deed itself, which the plaintiff has sought for.
Yes, next.
I tender my apology, my lord, for creating this trouble, my lord. I tender my unconditional apology. Beg your leave, my lord.
Thirty. Afterwards, next.
Mr. Conway Mohammed is likely for petition and lordship. He has not come to the court to refrain for not to do.
That is good.
I have the information regarding
So what is this matter?
I am not briefed in this matter. Fact. And
Sir, example, experience. You are a chamber junior. Solution.
Expert. I had concluded the hearing 1 year ago. Decretals of argument filed, but there are several dates being taken by learned trial judge to pass order because only one round, the volume of the file is heavy, so I need time. This is the problem.
It's application under Article 227 of the Appearing is from Kaji. Possible next. Yes. JKT is there. You are appearing.
But as first thing you lost, but I'm challenging the order by which I by my client. He is dependent on
Injunction.
Yes. The suit was for injunction.
Super for injunction.
That suit got an adequate order of injunction was passed against my client who is not the developer. I am holding a development agreement pursuant which I was raising construction. I have already invested 40 crores. At that junction, the plaintiff, the mail is by the plaintiff saying that
By the miscellaneous appeal.
so he plaintiff filed a claim contending that there was a development agreement executed by him in favor of my client.
So that can be taken.
No, that was pending registration. So not in that scope, he said that an order of injunction so that the defendant number 1, 2, and 3 may not raise any construction in or over the suit property as specific A and B without having a registration of the deed of development and power of attorney in respect of the property as described in Schedule A. This was not the principal prayer in the plain.
Page
34. Then look, the second prayer is defendant and the an agency restrained by an order of temporary injunction disturbing the peaceful possession of the plaintiff with respect to the property and from raising any multi-story building and or structures in or over the property and from transferring alienating and particle possession with respect to the property in favor of any third person or from changing the character of the property. But these are not the two main prayers in the suit, to which not I say that the suit is not maintainable with regard to the nature of the scheme. So that is one part of my argument. For that reason, I pointed out what is the scope of not this particular suit. So not kindly not come to the injunction application and the prayer.
What is the order which you are challenging?
The
Appellate court did what?
from the order of the trial court of
Identity refusal.
it was granted by the trial court. I prefer the misappeal. Ask for stay, but the misappeal has been dismissed.
This appeal has been dismissed. Mr. Mukherjee, there is no scope to pass an order of stay of an
The misappeal has been dismissed. Therefore, not the entire propriety of the misappeal court's order, which has not dealt with any other aspect which not the first appeal court should not have done about the merits of the matter. Your Lordship,
this distribution application has to be finally heard.
yes, my Lordship is appeal.
You are ready?
One thing. May this is the.
Are you ready?
I'm ready.
All right.
But let me. This is the application from an order passed as a temporary interim. The appellate court said that the trial court should hear out the injunction application of affidavits. Affidavits have been filed. Courts have performed the injunction. And the trial court and the appellate court has said it will not be influenced by the order of the appellate court. Now, while disposing of one interim order of injunction the first day, the plaintiff is not the defense case.
Defense case cannot be gone.
What the appellate court has done is said that the trial court should hear out the injunction application without being influenced by its order. So let the injunction start.
If it is from the victim injunction, and I direct, I file victim application,
Fine.
direct the file,
Fine.
then I direct the trial court to hear out without being influenced by any of
I
the.
set aside not the misappeal court's order. Why I say this? Your Lordship kindly comes and look at it. But there is already a decision against my client by the first.
Without being influenced, because
But
setting
even
aside,
if
setting aside the main injunction,
In the trial court, the injunction will remain. I'm not asking for blood, something blood which I'm not entitled.
So,
The trial court injunction, let it remain. He has already
So
filed a
what is
reclamation.
the effect of the dismissal is that Mr. Mukherjee is setting aside or not, because the effect,
Why don't you kindly have a look into the order, which
I
I'm telling you.
appreciate that, I appreciate that. So now you want the president to not want the vacating of the trial court's injunction.
I do want that. I do
You
want that.
want that, but now you are saying that let that, see, that if that remains, I give you liberty to file, you are filing a objection. What is the next date fixed? I trial court to take up the hearing on that day.
But I'm just
Without being swayed by the observations made in the appellate court, made by the appellate court. So we are covered because if it is dismissed, Mr. Mukherjee, nothing remains set aside. Because the other way around, then it would be without being swayed by any of the observations. Both trial court as well as
trial court did not have any observation, but that observation made by the first appellate court is not almost deciding not the merit.
I will say that without being influenced by that, anything, trial court, anything said may not be according to you, it may not be saying all observations without being, because Mr. Mukherjee, you know very well the scope of identity order of injunction and the injunction is different.
But my argument before your lordship is not fruitful. Based upon
It
your
is not maintainable.
one, and your
According to that-
95 CW, that no injunction can be maintained in the non-maintainable, having regard to the prayers made, and Lord, because of the nature of the injunction, Lord, the construction having proceeded, Lord, EC task is not will that they have to put into task, Lord, for the security. These are the 2 points that
So I record your this submission.
Well,
I give you a big praise of the, you have taken that in the written objection.
Lord, in the revision, Lord, I have taken this point, and in
The
the
written objection to the injunction.
yes.
If not, I will give you liberty to raise, to file an additional, or supplementary written objection to that, raise all these points, and I will directly learned trial judge to decide first the, maintainability of the suit first, then to proceed with the hearing of the temporary task.
Just take 20 seconds and take an instruction.
Because when the identity injunction was passed by the trial court,
That was passed in Lord. That was on 24/11/2025.
yes. So now, almost 7-8 months, sir,
Yes,
sir,
Lord, and
you are suffering.
construction is not, that is the difficulty, and they have entered into not a development agreement. This is an untwisting technique by them. They have gone to not the registration
Yes,
office.
Mr. Lai, but
The development
what is the
agreement has
real
not been
problem?
registered and asking
Once
for
you have, apart from.
No, there
once
is
you have-
property, one property they have had a development, other property they did not. They had presented the registered.
There are 2 properties.
Yeah. Two identical properties. If I show your lordship,
But Mr.
in respect of
Mr. Lai
Civil
says that the development agreement was with regard to 1 property and you are trying to develop 2 properties. That's what.
in respect of Schedule A, there is a development agreement. Schedule B is identical to the property. They say that in respect of Schedule B, I have been to the registration office. The registration could not be completed. Therefore, there should not be any construction in respect of that property where registration is pending. This is the sum and substance of this. That's the reason I read out the reason. In this circumstance, but they are looking for construction. 40 crores is not 45 crores.
Also that, where is the problem?
It's all about what they're asking for money. 45 is not a construction. It's the next step. They have to not secure not my
Only
money.
the registration, why are you fighting for this? One thing can be done, either civil division can be decided on merits or the trial court injunction. That's one way or the other. But the litigations will remain. So, why don't you-
They are asking for that I should complete the registration and construct. That is what they are not trying to say.
what is the difficulty in
Because
registration?
they did not attend the registration of
Why are you fighting out on this?
Yes,
If you say that you choose a day on which both of you will attend the
very well, not your lordship will kindly direct that. Not me, I just
I cannot direct. Both of you, I cannot direct from here. If both of you come to, otherwise, these litigations, one way or the other, either I decide it here or I relegate it there. This will not end here. or there also. This will not
It is
end
their
there or
admitted
there.
case that they went to the registration office. The son-in-law and the daughter, not the gentleman who owns the brother. Therefore, Lord, it was presented by them. Now, pending registration because
Yeah,
of
both of you-
non-appearance of the
Can
gentleman.
both of you take instructions, come back in the second half? Yes, Mr. Lai. Only with regard to this, if both of you want, today is the best day.
Yes,
So, this is the only thing, if both of Mr. Mukherjee says on instructors, he is ready to attend the registration office. You also want registration.
It is
Because
pending
your case is
registration.
there. Without registration, this should not be done. So
It is pending
registration,
registration. It is pending. Only because I am to Balashat, I have to
so
Balashat.
nowadays, Mr.
Well, I am not lost. I'm the advocate.
I'm keeping it in the, Mr. Lai, I'm keeping it in the second.
But I have a contact with the advocate.
Contact with the advocate if it can be done. If it can be
Can
done,
we get on Tuesday? As you mentioned. I'll come back. Tuesday as you mentioned. Monday is Monday.
I can take it.
I can. I have to call the advocate. He has to call the.
both of you come with a suggested date, I can record both of you.
But can we keep on them? Tuesday as you mentioned. On Tuesday as we mentioned, let us not come back.
Or the other way, I will be directing points which you are raising. Please check up in the written objection whether you have taken those points of maintainability. Already there, there is no necessity to do that. If not, I will be giving you a liberty to raise this point. If at all by way of a supplementary with a written objection,
I will take out a sort of.
yes, to rejoinder if he wants, he can take out the
The next.
so it can be done with this time.
1 week or 1 week they file, 1 week we file our opposition and then you can sort it out.
I think that better because hearing is neither here can be not sorted out.
I understand. If it sends back with one more round.
Here also nobody does, because this is adding fee. Even if it is disposed of one way or the other, it will be adding fee. Then temporarily will be there.
Then again, separate from that, then again.
Or if both of you want, I can send it to the mediator.
Well, let me, right. Slide is there, but
Because you have an experience. Art is we can do one thing I think because we will be getting maybe a short weekend, not a long weekend. So, that's why I am the expression short. So if you find that those points are not there, you can the draft of that, so that we may not be take this time to file your, and if that goes to that extent. We may not start, we may not do this for the next. Also, one next. Also, one next. Okay, essay application for the tribunal. Appellate tribunal you can approach.
So
There's a commission.
yesterday was order responsibility. ARTC units. Kindly direct the next day when it will appear from that day. Within some time, they may be disposed of interim order in my favor. Affidavits completed, ready for final. Since ARTC in December, January of this year, it could not be delivered.
Have you annexed that order when it was transferred?
But yesterday only it was.
Yesterday it was transferred to DRTC. It was pending where before that?
DRTC.
Essay is arising out of what? Is it 14? No.
No, I
Main proceeding.
Position has been taken that I am the owner of the power car park along with one. Sometimes the bank came and said your parking does not belong to you but another person who is the actual borrower and possession of only my friends. The tribunal considered both the deeds and found that in the bank's possession the deed that was there it said open car park. Whether from the position document it was clear that mine was a covered car.
The learned advocate
So there's a caveat. There's a caveat notice that
Caveat has been there. Then
has served upon the other thing.
maybe, but today you have also taken a decision. What is this matter?
Not sure it is against an order of which is allowed that application under order 617 primary claim.
Pass over next.
Item number 24.
Pass over.
Item number 23.
Yes. Explicit hearing. Explicit hearing of what? Junction application. It is ready for hearing. When it is fixed. 10th of February 2027. This application under Article 2. As explicit.
Item number 26.
ABA. Yes.
Partition of the was 9.
Order.
6 to 9.
What is the suit for?
Was expecting was running. With
What is
the
the suit for?
for declaration, actually paid for the demarcation of the land of the respective party. Page number, page number 17.
Yes, there is the pair for the demarcation. There is no pair for demarcation. Suit for declaration with regard to the gift deed and for permanent injunction. Where is the necessity for order petition? Now, what is the necessity order petition? Right. This application, this
But when you said
Yes, one at 1 p.m. please mention and yes. Yes, sir, we take up. Please wait. 1 p.m. We occupy.
otherwise,
What is the item number?
1
10. There is no KVA.
No. What point of property in one page?
Please wait, let the record.
Property. And this is a limited property of Mark and belong to the market. Third party is trying to transfer the property by way of the deed.
Please give me a minute. Please give me a minute, sir.
But option of this property, and he has no right that person who has made this
Yes.
when they can mention section 2 illegal where it is clearly stated that those who have
Who are you?
property,
Who are you?
I am the
How are you related to the testator?
I am the no not the I am the brothers and sisters, son and daughter. I
Testator left behind.
testator is aunt of my son, uncle of my son.
Yes. So
They
how?
are deciding the property.
Yes.
Person liable to pay tax.
Yes. By the issued order, what has been done?
In this order, that page
What is the infirmity in the impugned order?
trial court has decided that I have no right at
Yes, please show me how you have right. Please show me how you have right in the testator's property.
testator is my uncle, and he has
Have you given a genealogical chart?
Hmm.
Have you given a genealogical chart?
I have submitted for filed a project case and
That I appreciate. I will in a genealogical chart. How are you interested? How are you become interested in that project?
taken in my written statement
Yes.
that I have taken clearly that the stator cannot be transferred to property.
Etc.
The stator is not the owner.
That cannot be decided in a probate proceeding. Sir, that cannot be decided in a probate proceeding. Yes. Title can be decided in a probate proceeding. You have an authority. All authorities are against you.
I am submitted that
No.
nobody is the owner. We are deciding there.
Nobody is the owner.
Personal liability to pay tax.
Okay. This
Item number 27.
October next. October.
Right.
Yes. October next. October.
Item number 31.
October. Next. First. One next. About the petitioner.
Yeah, you can you want to can be like
Also the next. Yes, next. Who you are appealing?
respondent to the applicant paying for extinction of the
Title appeal.
It was filed by 2022 and thereafter one after
What is the application?
the application for substitution application was filed and then that I
Substitution allowed.
And there the check is a state and
The application number Article 220. Passover. Next. You are appealing. Let's see. Passover next. Number one. What is the application? You want the disposal of the lands and application. You have filed your written objection. You are which dependent? Number one. This application number
Arbitration application against award passed by the commissioner and the NHA. So 2016 was the arbitration application. State appeared after that did not appear, taken for order.
Is this for cross examination of PW1?
Only one PW1 from my side.
Was the claimant in an acquisition proceedings? This application are drafted. Pass over next. Any caveat is there? No caveat. Yes. Yes. 194 or 1194.
190, 190.
What was the reasons for the delay?
The rank officer, the lead officer who was in charge of this particular matter, he had retired a month after the meeting order of the TRP Hyderabad had passed. Thereafter, the new officer joined and the branch, the branch had also shifted.
DRT where?
Here,
How a civil division is maintainable before this court?
DRT Hyderabad, the essay was filed. Against the order passed in the essay, the appeal was filed by us to the DRAT at Calcutta. In filing the appeal to the DRAT,
It's not maintainable, sir. It's not maintainable.
it's an order of the DRAT Kolkata.
I appreciate that, sir, but the jurisdiction will be considered considering the jurisdiction of the DRT, not DRAT. Because DRAT Kolkata is having the appellate jurisdiction of several tribunals situated throughout the country. Jurisdiction of the High Court will be decided not as per the sitting of the appellate tribunal, but as per the sitting of the debt recovery tribunal. So I have decided this point. Who judges? One we can just consider those judgments because the DRTs at Hyderabad we cannot maintain because there are several decisions on this. I've considered that and under several statutes, Income Tax Act, Consumer Protection Act, we're finding a decision of the Consumer Protection Act where it says it went from Calcutta. So the Consumer Forum, District Forum or State Forum, I do not exactly recollect. After that, the National Commission at Delhi. From that, 227 was filed to the Delhi High Court. Then it was entertained. Challenging that, it went before the Supreme Court. Delhi High Court did not have jurisdiction. You have to go to the parent court at Calcutta. So, if you want, you can come back because when you want to withdraw, you can also come back. Yes, please, not on Monday, please come on Tuesday. I'm keeping it under the heading to be mentioned because this will be, please consider those judgments and come back. Not know the exact reference. I can give you the names of the councils to appear. That much I can do. One is Mr. Vishnu Shah is one of the for the petitioner. The other matter, Mr. Moina Kushak. So both of them appeared. You'll be finding another judgment prior to that, which also have considered delivered by Justice Bhaskar. But there is also a contrary judgment of another Justice Bhattacharjee who also have considered that. There is contrary judgment that is in your favor. But I have considered both and all of the earlier one. So, I'm thinking Tuesday, I'll consider. Please consider this. The this was So next, food. What is the food for?
Question, my lord, which is said, my lord.
What is the stage of the suit?
Another issue. Stage of claim of issues, my lord.
Issues framed.
No, my lord, subsequent issues failed. Subsequent and amendment application was filed, which was announced on the. Thereafter, my lord, the defendant sought for amendment, additional statement of evidence. Since then, my lord, last chance and last chance. Every day, my lord, further last chance has been granted by.
No special chance given.
My lord, special chance 3 times, my lord.
Then again, faster.
My lord, I don't. Since my lord, 25th November 2024, the amended case was filed and additional numbers and not all subsequently 5 7 days, my lord, last chance, additional chance, special chance. I'm just praying. God make this matter.
This application. Afterward, afterward. Yes.
The relationships of the opposing parties hearing, my lord. She has obtained a degree of feelings against whom, my lord, feeling calculate people than happy. Happy was weak for hearing on that day, yes. He beyond that. And my lord, we have find that application, the happy was adjourned for taking state. Whereas we requested the parties names of they are not submitted. Whereas we have appeared the executing court. They have also filed an application. No direction was given for service. They are not filed. Ultimately, my lord, when after making the inquiry, they have filed it. There was a delay of 3 days. In
By the substitution application. Yes, but there was a delay of 3 days.
3 days. The application evaluated directed initiated a mistake and directed for service. But we made before the court that such a situation is put up for free of the fixed and matter order has been passed on. That application has been rejected by the appellate court on the ground that order for demand file is not absolute, so that this case is done. Also, we find an application one. My lord, we are wanting, we have find an application. For record of the article one. And I am here. That is it.
What can be done? If the appeal has awaited,
Because we just find whether there was we have detailed in yes statement. And whether this has been now fixed at 20 September, we have filed the whether
that is for execution.
the execution has been fixed in this month. Very fast. And June. But on 29 July last, that was now.
Before this, were you enjoying in order of stay?
No, because the appeal immediately whether kindly you give the appellate court order on my prayer whether the case was
What's the degree of eviction?
degree of eviction. We want for hearing and hearing date was fixed on that date whether the appeal.
So, if you are entitled to an order of stay, you have to deposit.
Whether that I should pay my lord unless whether but that is not exactly the application.
Please put in some amount. What is the property? When the decree was passed, please show your bona fide. Please deposit some amount as a condition for stay. What is the property called? What is the suit property?
This room property one room. Whether it is
One room. This is commercial property or residential?
residential,
Where
in a
it is situated?
bigger property and same for our
Howrah. What was the name?
same was murdered. Rupees 100.
What is the square feet?
This square is small room.
What is the market rate of rent, Mr. Mitro, of that locality? Of that
Whether
degree passed when?
the degree passed from February 25.
February 25.
That bill was fixed on 4th February 20.
Deposit 20,000. 1,000 will be the minimum rate.
My lord, kindly,
Sir, one room cannot get less than 1,000. It will be deposited, it will be adjusted thereafter, considered, asking you to deposit a lump sum amount. I'm not fixing any occupation. Deposit, please show your bona fide, deposit that.
10,000, madam, kindly
A
consider.
thousand, more than 12 months, it's 17 months. That is why
17 months, madam.
15,000, deposit 15,000. So, with the example, scheme is, so because, Mr. Mitchell, even assuming that you are entitled to maintain an application for stay, you are liable to pay on it. So, that you have to do. By the order in June,
Act number 27.
So which was also KVA?
No.
Yes, I have difficulty taking up.
Somebody else.
Then if you have difficulty, I can leave.
Your lordship, somebody else discussion.
Act number 28.
Pass over. Next. Pass over. Pass over.
Act number 21.
Pass over.
Act number 20.
You are appealing. Yes, sir.
Let the on filed an PMS under section 8 of the civil code.
What is the order you are telling me?
I filed an order 770, order 711, that order 711.
What is the ground that order?
In the suit, my lord, they have prayed, they are challenging the deed. And
Challenging the deed.
challenging the deed, my client is the, my lord, the purchaser. My client is also kindly see the
Yes.
prayer deed, my lord, kindly for declaring that the deed was as null. On that ground, my lord, I find an order 711 since the direct stipulation does not appear in the dispute. When they understand their mistake, they file an application order 670. Rectifying that defect, that deed is sought. What the landed court will do, without considering that order 670 dismiss by criminal. Without considering, if the plaint is amended subsequently, order 670, then my lord, I have no option. Kindly see the
So by the improved order, order 617 has
not been touched. Although that is pending. Even one part the deed value is more than 60,000. The landed civil judge will get it. Because the deed has been challenged. In the fair deed, the kindly see the deed is null.
even if one of the pair is barred, can a plaintiff be rejected?
That is the root of the matter.
I'm asking.
But that
Even
judge
if one of the pair is barred, and the other pairs are maintainable, can the suit be plaintiff be rejected on that ground? What's the law on this?
let's see, that has not been touched by the so the 670 was
No,
filed.
your case is not that pair A is barred. Your case is not that pair A is barred. Even if I accept that the pair B is barred, can it be a ground for rejecting the claim when some of the pairs cannot be said to be barred? What's the law on this?
Because we will get using the root of urgency and judgment, my lord.
Brother, you are not following my observation. There are 4 players in the play. Some of the 2 of the players are barred. 2 are maintainable. Let us take this thing. So I'm asking you, can a play be rejected on that ground? Expressly barred, 2 of the players. But 2 are maintainable. What's the law on this? Can a play be rejected on that? If not, the order is right. Yes, I'm right. You are right that the technically order 617 ought to have been hard passed. Even without that, even if let us assume your best case is order 617 gets 16. Let us take your best case. Even then, can it be a ground to reject the claim on the claim as it is? Cannot be done. Because case and case is mentioned. What's the law on that? I'm accepting that, but the answer is maintainable.
We are should be, my lord. Order 670 should be hard first. Suppose, my lord, it has been
Sir,
rejected.
it's always open to a party not to press it. It says, both says, I do not press that. That's always available. It did not amend this way. You can go under order 23. You can do that. If you want, I can clarify that. Order 670 will also not be. That is the application under order 670. That can be allowed straight away from there. We will not be prejudiced. I can pass it here and now. Because it's open. Where is the application under order 670? That can be allowed from here and now. From here it can be allowed.
Because when the
Order 711 has to be infracted.
when the understand the mistakes they have done.
That's the law. Can be done. It's a curable, can be done. For that, order 7, if both applications are filed, order 726, order 727.
That is valid, my
Here, even if it has not been done, you do not have any of case in order 721 on these facts. Where is the order 627? Again, exact.
that has been page 9.
Page
90.
94.
92. 92.
92 starts.
Starts at
Where is the
96 and the schedule is 99.
Yes. Right. Can it be done? I can allow it here as well. From here, I am allowing plaintiff has a right not to press any of the players at any point of time. You cannot oppose that. I am allowing their order 617 here and now. They will not be agreed. And 227 also that can be done. Can be done.
This is not fixture of this order.
No, I appreciate the field order. There is no difference. Sir, was prayer. He has made 2 prayers. He does not want to press one of the prayers.
That has not been done.
Order 23 at any point of time. What not to have filed an application order 617. That was a surplus. Because straight away say they are not pressing.
Yes, that but there is
I'm allowing order 617. Where is this code? Amta, Sagan, come back. I'm fixing it on Wednesday. What in the meantime? What is the next date, please?
Yesterday was the
I'm putting you on notice. Order 617. I will be allowing them from here. You start. Let them come. If they have any objection, by the order impugned, the application under order 711 of was to reject it, and the date has been fixed for hearing of the application for and the date has been fixed for hearing of the application for amendment of code. Mr. The learned advocate agrees for the petitioner submit that in a preemption case, the opposite party, party number one has challenged the deed by virtue of which the petitioner has acquired right title and interest in respect of the property which is the subject matter of the preemption instance. The study submits that that insofar as the relief for declaration is concerned, the learned trial judge lacks the pecuniary jurisdiction to consider the same. The petitioner is directed to serve a copy of this application upon the opposite parties by registered speed post with acknowledgement. What is the next date, please?
Article yesterday was like this.
What is the next date? 31st was yesterday. Petitioner is directed to serve a copy of this application upon the opposite parties by registered speed post with acknowledgement. This is matter of the motion on August 10, 2022. What is your idea? 51 was passed over. What is the same matter? Analogous matter.
Same.
No caveat. Where were you, Mr. Chakraborty? What is your idea? 94. Seventy allowed. What is there, Mr. Chakraborty? I am expediting the suit. Why no? Yes, sir. What is the ground of challenge, Mr. Chakraborty?
Under post on 4th of July 2025. 4th of July.
No, summons was served on 4th of June. Where is the order? Please show me.
That is to actually claim
Not according to the plaintiff, the records will show.
that is fine. But we have when dispute is the same. I have stated that by two post will start on after 4th of July 2025, and on 18th of July we appeared, and on 31st July I filed the application on the 7th.
No, you have put your signature on 4th of June.
No,
That's the finding, sir.
I have disputed this.
If you want,
That benefit has not been examined. Benefit has not been examined. Not the defendant has been examined, not the plaintiff has been examined. What are
Mr. Chakraborty, those were available on that 90. No, it's there. You have not deposited within time, gone.
Yeah, my lord.
For that it was amended and these two vice and other things are.
Yeah, my lord.
Yeah, that's a specific finding. Mr. Chakraborty, if you want to dispute that, because this finding, I cannot in 227, I cannot interfere with this factual finding. If you say that finding is wrong, you have to go back.
I have filed the application, but I filed an application that we are on page. what you want. What you this what you that application on a student. And it's page 38 onwards. Page 38 onwards, I have stated. Paragraph.
Order line, rule line.
Well,
Under order line, rule line.
One that's the mistake, my lord.
What was your prayer there?
My lord, this application, my lord, I see page 40. Page 44, I have calculated stated. Page 44, paragraph 11. That as the petitioner defendant is person regarding his respective laws and only postal summon has been received by the petitioner defendant and no summon has been served upon the petitioner through court by process of the learned court as per the knowledge of the petitioner defendant. The application under section 172 of the was filed before the court on before receiving the summon to post on 4th of July 2025 and an order has been passed on 31st of July. So my lord, if my lord that fact is taken, my lord, I have disputed the
Where is the application under section 72? Please show me.
my lord, I have annexed my lord. This fact has not been stated.
Then
My lord, yes, but it has been stated, my lord. Stated that someone has been served to post. I have
you have not stated that. It's a proposed. Do not now improve your case. You have not stated that fact specifically.
my lord, kindly see, my lord, I have
Where is the order under section 72?
seven order that order, my lord, kindly see. That order is, my lord, your lordship, order number 16th of April 2026.
Where is your application under section 5? Yes.
That application,
Under section 72, where is your application?
page 38, my lord, is the application. Page 38 is the application.
Yes, 38.
151. Order 9, my lord, what I say, my lord, these have been quite, my lord. Either I say, my lord, my case is, my lord, I have not been served to very. So, if, my lord, that fact, my lord, your lordship is to consider order 5270, my lord. Order 5270, I am disputing. Order 1900, whereas someone is returned under 270, the court shall, if the return under the rule has not been verified by affidavit of the serving officer and may it has been so verified, examine the serving officer on oath or cause him to be examined by another court touching his proceeding and may make such order. So the postal cure has not been examined. So I am disputing the service under by the court. I am saying that on basis of the postal service, I have filed the application and that is within the time. 4th of July, it has been posted. 18th of July, I appeared and 31st of July, the application has been. So, my lord, balance the orders you want to orders are but not that I am delaying the matter for a long period. Avoiding at the earliest possible opportunity I appeared and taken steps. matter is to the partner. I have also challenged the order of under 7 clause that consequential order has been passed. Totally, I shall be mentioned. Person is
When you file the application under what is the there was area rate? Have you deposited that area rate?
as per my opinion, I was
There is no admitted rate. Admitted area are there in
I have stated where I was depositing rate. I was the assignment fantasy. It's a 151 application.
File the application on which date? 18th of July 2025.
No, 31st, 31st of July. At least my post end on 4th of July.
When did you appear in the
Appear on
suit?
18th,
When did you appear in the suit?
18th of July. That will be reflected from the order statement. That will be reflected from order now. The second page of the order statement, second page. First page, my lord, on filing of the suit. Second page, I appeared. And thereafter the order. Well, that is वो लकाटक सिग्नल बनाने आया completely appeared and taken steps by your handled by your by the other name like perform them.
Amongst two posts you have received when?
After 4th of July, under administrative, 18th July appeared. 4th of July, administrative.
Mr. Chakraborty, Learned Advocate, appealing for the two tenants, same thing. Then there's something.
Order is the same order.
Thing. PM I have come. Yes, sir.
Fixed on Monday as we are also studying. It is a heavy matter, my lord. Kindly because it was a
Today is the best day.
matter of
Well,
Mr. Shapasan has requested me not to.
Monday fixing a time.
But already it can be kept. Can be kept with this.
Yeah, here fixing time on Monday.
Your watchable recall
Your
is
item is
94.
94. Please comment 2 PM. There is, I think, I fixed another matter on 2 PM. After that, it went 94 to master 83. It will not reach serially. Wait, 83, 94. 100 job today I can fix. 2 PM. That day it will.
Let it be at least in the
All these are fixing for today.
at least let it be there in the list.
It will be there in the list.
So
Do not go out of the list. It will remain there.
might not just let tiny pass like a product.
56, 54, 54, 56. Combined is today 800. No KVA. No KVA.
806.
79.
79. 79 of 50. 79. Plus 70 yours is 83.
68 to 70.
60.
8 to 70.
No KVA. All matters will be taken up. It's better to proceed serially.
112 very good.
112 का 112 है ना my parties are there. Both of you are ready. Then it's better to proceed serially. 61.
58 is also not Kevin.
61. Yours is 61. Yours is
54.
ignore.
I feel that I'm saying what's happening there. In case if it doesn't reach equal to 3, it takes it as well change it.
110. I think better to call serially because most of the matters have been.
94 I had mentioned early in the morning. Mine will be accepted.
110. Yes, your matter will be taken up as the first item. Proceedings mention matter serial. And
I had
yes, yours will be taken up. What is your item?
156 of the combined.
Yes.
110.
Not T. Both of them mentioned in the morning. So
Absolutely.
thereafter
Get
the
the precedent.
mentioned matter will be taken up first serially thereafter. Yes.
Part is what? Item number 156.
Huh? So Bondwada, there is no KVA. Yes.
Good. And what we can do. That I want to but I appreciate also on the ambition because there are going to be because I say so because if your losses are not with me on the maintainability, then we are addressing your losses on the very skill,
Yes.
only waste your losses.
Yes.
Precious.
Only on the maintenance.
But in that regard, but we had this adventure. That is 2019. What is 250. But kind cakes was
2019.
19 4 is 61. But in kind cake, paragraph 2.9 was thereafter I think you look at the operating portion 2.9. The main reason.
Yes, yes. That there against a refusal, an appeal was preferred before the district court. So thereafter, so I'm also saying that first is you have to prefer an appeal before the district court, then you can come, not directly.
2.10 also it is recorded. 2.10. Same thing has been recorded.
But the factually is distinguishable.
Well, you will also kindly take the principle which has been enunciated. 6.1 and 6.1 and 6.1.
Yes, yes, I've seen that. I've marked that. Please see. I've marked that.
I'm
But
sure.
here it's a distinguishable. Here it went from the refusal, it went to appeal. Thereafter, 226 it was said by 226 maintainability was not challenged before the High Court because against the order of the Civil Court it should be 227 and not 226.
But this has been relied on by Karnataka High Court also. Well, also,
Mr. Bondavata, there are saying even it's a refusal here in your case. It says only if notice is served to propose, then it's also applicable.
but the Karnataka judgment,
That's not binding. That's not binding upon this court. There are authorities by our court, Mr. Bondavata.
kindly looks into the distinction of ex parte and after giving this to the other side, which
Mr.
makes the order
Bondavata,
adjudicated.
have you brought our court's decision anyone?
So, I have brought one Madras which is against me. But if you look,
Our court, there are series of judgments
kindly look in one paragraph of
of
Karnataka. One paragraph. What the process is done.
but the binding precedents is against you. Okay? Paragraph
But I could have placed 4, 5 and 8, but your lordship may take 8 only.
yes.
Insofar as the third contention of the learned counsel for the petitioner is concerned, the refusal of an order of injunction can be subject matter of proceeding under Article 27 of the Constitution. The same would have been so if an ex parte stage, the relief of the injunction is refused by a trial. In the present case, as can be seen from the executive order, the same order has been passed after service of notice on the defendant, and after hearing the plaintiff and the defendant as such, after an adjudicatory order had been passed, after the hearing on the parties to the proceedings under Article 227 of the Constitution, exercising supervisory jurisdiction is not permitted. Therefore, my lord, this distinction has been drawn that where it is upon notice, it is adjudicatory in nature. That is why 227 will not be applicable. But if it is my lord ex parte,
That is omitted. That observation is omitted.
my lord,
That was rejected. On that, omitted of High Court is not binding upon us.
definitely.
So,
But my lord, my
This
contention
is
is
not
that
an issue.
the issues were framed in this judgment in Karnataka, and the third issue has been decided in this.
That issue was not jargon in the facts of that case. So, my observations are omitted, not binding. That apart, was persuasive, even if
I understood it to be my lord, part of the ratio of the judgment.
it's not happening because there it was decided on merits. So this is omitted. This was not the issue framed or the facts. On facts that question did not arise. But the court on its own framed such an issue that is omitted.
But if your lordship takes my lord 4 and 5,
Mr. Bondavata, it's well settled. All precedents are well settled. And regularly on this are passing orders.
in that case, my lord, kindly grant me liberty to
Yes, that
appropriate recourse to law.
because this is the long-standing precedent for your cases of rejection.
Objection. My lord,
But on case, you will be finding on a much better case.
Well, I was trying to find support from the 2019 Supreme Court only because it was a
2019 appeal was preferred. Thereafter,
came.
so factually that's also different. After some
but all the instructions for the giving the adjournment at the count of the others. Triangling to do the matter. So that matter which is Shakosh and Arthur, my execution is same.
So substitution is not available. That was what it was.
Yes, yes, right. He was being fair that means, but I told him you should wait for Arthur. I don't know what we built upon him. I apologize to the bench and wait for my turn.
Well, well done at all. Yes.
Follow. Against order. This is my application under order 627.
Worry.
After payment, just two alert for settlement of accounts and recovery of money, 5B20. Well, let me admit, this amendment which I have sought to the report below was a post trial, but the observations for the deepest of respect are incorrect. Because what I sought for at the first paragraph of the claim, I have written the partnership registered was by an act of omission this I was registered in 2001. And in the prayers, there are certain typos of yes.
Where is your application for amendment?
One. So you kindly come to page 20. Now the schedule mala is at page 20.
Where is the claim?
Again, mala starts at starts from page 8. Page 9, mala must come the first paragraph. Written there, plaintiff is a partnership firm within the meaning of the contract. I have incorporated the word register, bearing registration number of my amendment application. I had also in annexed the registration certificate, supposed to show that I have been registered in 2000. This is one aspect of the contract, and others some typographical mistakes in the prayers. This is what I have sought. In prayer B, decree for declaration that nothing is given payable writing.
What is paragraph 3? Paragraph 3, there is no change. Why are you wanting paragraph 3?
Paragraph 3 malani.
For example, says directly.
Decree malani. I don't know malani. It's not correct. Decree to inclusion directly. These are the malani amendments which I have sought. One of the learned judge observes that I have changed the nature and character. It has open trial. I have introduced new further action. lays down certain parameters in case of post-trial amendment where due diligence is not due. In which paragraph 22.
There is no embargo in allowing post-trial amendment. You have to satisfy the proviso. It's one thing, and another is
Absolutely.
another is nature.
Nature and character cannot be followed. It goes without saying. But my lord, Lordship knows in the proviso of order 670 he posted it said that you have in exercise of due diligence. That one. That my lord, quoting that, the learned judges said not in every case.
Yes.
Due diligence has to be considered. That part is very 25. And he lays down certain parameters where Malad it is not. It's a very interesting judgment. No Malad is not Malad. Has got some persuasive background. There is a problem.
Yes. 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 What is the challenge? Order 711 rejected.
Allow.
Allow.
Yes, I got the same advisor. When they find the order 11, now reject my this case.
How can a revision lie? How a revision is maintainable? Order 711 allowed. It's a decree. Deep decree. Now here, if it is allowed, you have to file an appeal. What is Abdul Mutin Mulli? Short consideration.
Yes, fine.
What is there, sir? Nothing. Only it will be delayed. It will be relegated to the miscellaneous appeal. Same fate. Sir, after Balasar, Abdul Mutin Mulli.
I was
What do you now want to?
I have to withdraw the appeal and file an application.
That will be only time and minutes. Because this is settled after the office. And those judgments have been quoted. So what will be there? The learned advocate appeal for the petition is for the
I don't know if it takes.
Because you have mentioned, Yes. Speak to the microphone. Yes.
And I have the take, and you have the take this tripod and island application for application of the tree, the application process. And then my application to
Please give me a minute. Where is the plane? Page 15. Give me a minute.
character I have character of cabinet
Yes, sir. What is it?
I square.
Yes.
That after time and will certainly change the nature and character of this.
Oh,
Kindly see the schedule of the place.
yes.
Even notice has been already that is in respect of a factory land measuring about 47 feet, 25 feet, and one cut something like that. But not in respect of any premises. That is
Not
the
in respect of any
in
premises.
respect of premises number 44C Strawberry Street. But that doesn't fall under the Westmoreland premises tenants that packet land. Packet land cannot come within the purview of section 4, section 2E of the Westmoreland premises tenancy act. That's why the degree passed the penny. It's a nullity. That was the submission made by me before the first appellate court. And I had shown the exhibit 5 that was given by the plaintiff in the trial court, where the tenancy was particularly
Very good. You have a copy of that,
Yes.
right? What is that document?
exhibit with the tenant that was the defendant, plaintiff, and the agreement page 22 and 23.
This is the agreement dated 18th December 1971.
1st December 1971.
1st December.
1st
1st
December
December,
1971.
1st December 1971.
91. And this was exhibited by the plaintiff before the trial court as exhibit number 5. And kindly see paragraph. Kindly see the schedule. Schedule of the agreement. That is on the vacant land. Paragraph number 2 and 5 are very important paragraphs.
This agreement has been marked as Exhibit 5.
Exhibit 5.
Have you annexed the trial court judgment? Trial court judgment has not been annexed. You have the copy of the trial court judgment. You have the trial court judgment with you. You have a trial court judgment with you.
It has been written in the first appellate court judgment.
It has been written. No, I want to see the trial court judgment. That is annex.
Current one, I will kindly see the notice, ejectment notice. It is at page 20.
What is the number of the suit? 333 of 20?
333 of 2010.
Yes, what is page 43?
Trial court judgment.
Yes, so it is here.
Yeah,
Exhibit 5. Yes. Yes.
kindly see the notice, ejectment notice. That is at page 27.
27.
Second paragraph. And the notes we have given. And that copy I am talking. Not in the store application.
27 is the verification part.
Not in the store application, but the
So this in this.
legal notes I have given. I have given the certified copy of the notice.
The no.
Right.
Page 27.
Page 27. Second paragraph.
Yes.
And the suit has been filed in respect of the vacant land as was section 2E of the welfare of that not maintainable. Your lordship kindly see annexure you may take note the page 30, page 32. Honorable Justice, the comfort also held prima facie that the suit is not at all maintainable. Kindly see
What happened to this civil design application?
that reason that the defendant was a very poor man, not prosecuted, that was but
This is for default.
this is for default. But prima facie observation is there that according to section 2B, the suit is not at all maintainable. Kindly see.
What was that? Oh,
Application. What was the civil division application?
In the civil revelation application, an application was filed under section under order 7 rule 11 for rejection of the plaint, and
So that was rejected, against that you came.
that was rejected. Against that this application was filed, and now they want to bank upon the plaintiff want to bank upon their paragraph 1 of the plaint, where they have wrongly written that the premises is a land along with a structure, but that is never in existence. But
Agreement also does not say so.
agreement also does not say so. That's
You are
why
not disputing the agreement.
no, we are not disputing the agreement. So the amendment, if by way of amendment they want to induct the structure, amend the structure, that will change the nature and character.
So point has been taken in argument for the
An argument was already complete on the part of the
appellant defendant.
appellant defendant. Thereafter, this application was filed for amendment.
Yes, what do you say?
Your Lordship, the structure, plaintiff, paragraph, page 16, plaintiff hearings in respect of the land measuring about 11.11, 175
Mr.
square
Chatterjee,
feet,
do you have a SCC
one
online with
katha,
you?
10 chatak land. You'll,
Please take out 2005 13 SCC page 89. Yes.
uh, it,
Have you brought any decisions?
Your Lordship.
What?
Lordship, several times, Your Lordship, in earlier occasion, earlier matter, Your Lordship, post-trial, Your Lordship, one senior counsel has pleaded in this matter, post-trial judgment. Due diligence. As Your Lordship, I have already pleaded in my plaint, Your Lordship. 1075 square feet, one katha, 10 chatak, 5 square feet land, including tin shed, Your Lordship. If Your Lordship, if the degree, if the trial is succeed and appeal is fail, Your Lordship, and execution will be travel, Your Lordship. In case of execution, Your Lordship.
Where is the judgment?
Peter.
Where is that judgment?
If the Lordship, if the amendment is not allowed, we have to file another suit for the rest of the portion, whatever. Your Lordship, I am the owner of the.
Where is the, have you carrying any judgment on that point?
Your Lordship, I am not carrying any
You are
judgment.
not carrying any judgment. You have found out Sajjan Kumar. Is it Sajjan Kumar?
My lord, one কত ছিল ওটা? এটা
23.
জানি।
এটা দিন ওনাকে। Sir, do you have anything to say on this judgment?
My lord, firstly, I am to say this.
এই ওনাকে দিচ্ছেন।
Kindly
Look at this judgment once.
Civil Procedure Code Order 647 amendment declare and file a stage of the suit when permissible. Imposition of cost, incorrect description of suit property include proposed amendment necessary to bring in controversy between the parties to 4. Refusal to permit amendment likely to create needless complication at the stage of execution in the event of success of a plaintiff in suit, though the appellant plaintiff
বুঝে নিয়েছি। My lord, this judgment is not applicable in this case.
Why?
Because of the fact, your lordship kindly see the exhibit 5, paragraph 4, where your lordship will find that the structure is at the corner of the vacant land. If it is on the corner of the vacant, left hand side corner of the vacant land, then it is not within the vacant land. The suit is against vacant land. They have filed the suit against the vacant land, but there is no structure there.
Yes.
So the suit degree itself a nullity. I argued on
Mr.
that
Chatterjee,
point.
please.
This is food for partition. That was filed in the year of 1950.
What is the order under challenge?
Lordship, last page, Lordship.
What is the nature of the order?
Order is this substitution application has been dismissed.
Please use the microphone. Substitution application
Has been rejected, Lordship. Initially allowed, there are
substitution rejected.
yes, Lordship. This is the reason.
No, not substitution. Order 22 rule 9. Setting aside amendment.
Set the amendment, Lordship.
Why are you saying substitution?
Lordship, initially rejected, then I filed this application, Lordship.
No. You order 22 rule 4 was allowed.
Yes, due to latches of the learned act, is not comply the order of this. That is the.
What was the order of the court?
Just kindly see page 50. First is page 51, Lordship. Time prior, but he has not complied in spite of giving a time. This is the reason.
Where is the order allowing substitution?
Lordship, page 50, Lordships.
Page
50. Order 70.
The issue that arises for consideration is the issue that 58 ও মেনশন করা? Yes. Yes. What do you want? What order you are challenging?
Two orders of January, orders of on 3rd January 2026 one, and another is the 86. That is the I am on expert.
Yes.
And being a defendant.
No, ex parte, why? You did not file written statement.
After searching the record, we find that some documents have not served upon me along with the summons. Only 5 order. Despite pending the petition, Lane Court decided to refer.
Have you filed your written statement or you have not filed?
Not filed. Not filed.
Till date, you have not filed your written statement.
I am an expert.
Ex parte, I appreciate. Thereafter,
I am filing the backing of the petition of expert.
what was your ground? Please show me your application. What is the suit for? Of a tenant, licensee, what? 1997 Act. 106. What documents you require? Under Order 11, Rule 15?
Which the petitioner relied on?
What? What is necessary? What did you relied upon?
Some deeds, but
You cannot challenge the title. You cannot challenge the title. Then
why? How can I submit the written statement? Because I have to.
what is the scope of your defense in a suit? You can challenge the title. Then what did you want? You will file an application under Order 11, Rule 15. You will delay. You will not file the written statement. Those things are gone now. 106 suit. What is there, sir? Order 11, Rule 15. What documents you require? Where is your Order 11, Rule 15? Please show me. What documents you require? Sir, have you prepared a draft of your written statement? Can you prepare a draft of your written statement? Within how many days? 1 week. All right. Please come with a written statement. Ready? Then I will consider whether you will be allowed to. Now you don't require any document now. The Please come with a ready with a written statement. No, these documents, that documents. Yes, next. Of what?
So is the suit for declaration and permanent lordship the defendant has
What is the stage of the suit?
written statement by
Written statement filed.
yes, sir.
Cross examination of PW1.
Yes, sir.
This application under Article 227 of the Constitution. $68 feet আছে যে 68, 69, 70 একটা বললো যে নোট করেননি আমি Yes, what is this matter? All of the suit. Who are you?
I am the defendant, your lordship.
Yes.
And the defendant has been filed under the praying for a declaration by the plaintiff that he is liable to stay in the premises.
Order 7, Rule 11, what happened?
Your lordship, the first
You have filed an application under section 5 with 8 and 5 with arbitration. That has not been disposed of.
that has not been disposed of.
30th of September. It's ready for hearing. Objections filed.
Objection by your lordship on the we have filed the application.
This application under Article 227 of the Constitution of India শুধু 70টা শুধু সুটের নাম্বারটা চেঞ্জ হবে। হ্যাঁ, সুটের নাম্বারটা হচ্ছে এটা।
Well, the plaintiff is enjoying an ex parte ad interim order of status quo, Your Lordship. This application was also filed under Order 7, Rule 11, long back in October 2025. And since then, the matter is.
না না না, এই ভুল ফাইল দিলেন বোধহয়।
Your Lordship, the plaintiff is enjoying an ad interim ex parte injunction order of status quo, Your Lordship.
So your order 7 rule 11 is pending.
Yes, yes, yes.
This application under Article 2. $75.
Your Lordship, the learned counsel.
You have mentioned this for taking up. You have not mentioned. এটা কি হলো? কোথা থেকে পেলেন? All right, not today. Next. কোনটা আছে? Yes.
They have filed caveat, and there was no opportunity for me. I move it before the court for identifying instruction. Since 2024, my lord.
You are the defendant.
No, I am the appellate, representative.
This application under Article 227 83, yes.
I am appearing for the plaintiff decree holder petitioner. My lord, what
Plaintiff degree holder.
petitioner?
So execution is now.
In the execution case, what happens? My lord,
Execution.
execution. Well, I am the decree holder.
That is what I am asking you. So at the execution,
At the
the problem will start at the execution, not before that.
Now, my lord, the decree holder, my lord, points out to
happened?
the court that if there is a misdescription in the suit property, bailiff goes. Bailiff was registered by the defendant. Identity of the suit property is not in dispute. But, my lord, what happens, my lord, in the schedule, the butted bounded, my lord, there is a misdescription. My lord, the plaintiff decree holder files a petition to correct it. My lord, that has been rejected, saying that as the bailiff has not yet reported that, that's why I will not correct it. That's the order in view.
What is the application for amendment? This you want to correct the decree.
No, the schedule of the schedule in the Miller tabular statement of the.
But the decree, unless you correct, how can it be
But-
corrected in the tabular statement?
Two applications have been filed.
One
before the suit court, one before the executing court. Both
One for the correction of the decree.
decree and Millard, one for the one for the correction and one for the correction. Of
Plain.
Millard takes up the application, Millard, that which is before the suit court. Millard, the prayer, Millard.
No, plain schedule.
Millard, kindly takes up page 49. That's the application before the suit court. With a prayer to Millard.
Big built one go down space.
Yes.
Butted and bounded by this.
Millard, this butted bounded on the north, it should be incorporated. This after the word a shop room. And Millard, in this south.
Where is the amendment application?
Millard, after the decree, Millard, I cannot file an amendment, but my application before the suit court is to Millard correct the Millard decree. My lord knows this can be done if there is no misidentification of the property.
Misdescription of the decree you cannot correct unless the plaint is corrected, Mr.
Millard,
Chatterjee.
my
How can you
application.
Because the decree has to tally with the plaint.
Yes, my application is page 49. 49
Mr.
before the suit court.
Mr. Chatterjee, there is no defect in the decree as it stands from the plaint. So if there is no defect in the decree, how 150 to 153 lies?
Kindly
150 to
appreciates in
153.
section 47, Millard, due to misdescription, if can be a cause, Millard, where Millard the question.
But Mr. Chatterjee, if the decree tallies with the plaint,
Yes.
how can you correct under 150 to 153?
Millard,
Because there is, you cannot change the decree from the plaint schedule.
no.
How can you change that?
That power, Millard, is vested, Millard, even with the executing court. Millard, in section,
Without the, you can amend the decree
Millard, I have
so that there will be a different schedule of property in the plaint, different schedule in the decree.
Millard, I have a decision, Millard, which says this can be done if Millard permit me to hand over this.
This is your matter. That is why you are ready with those amendment decisions.
No.
You are readily finding out those decisions when I was telling you.
No,
You are very glad to find out those.
No, Millard, this is on the power of the executing court even to Millard correct if identification is not a problem. Millard, this is by Allahabad court.
Mr. Chatterjee, you are having judgments of our court also.
We are also having. Millard,
So where are those?
That I could not.
So you have gone, you have traveled that far to Allahabad, but you could not travel within the state.
This is very recent. That's why Millard brought. Well, I know Millard, our courts, I know Millard, my lord knows that why.
Don't care to bring those.
Identification is not in dispute, Millard.
You don't care to bring those, Mr. Chatterjee.
I should have, but Millard, since this was recent one, Millard, that's all.
It's not a binding precedent, Mr. Chatterjee.
Our court, my lord,
This is not a binding precedent. Then
law is Millard very, Millard, my lord knows it, Millard. Even Millard, at one.
is it binding, Mr. Chatterjee?
Other courts are not binding, but definitely have a point since our court has also delivered.
You will not bring the binding precedents, will be those judgments which may have a persuasive.
I'm aware of our courts.
No, I am not aware of anything. I'm aware of some judgments of our court which are against you. Because readily it comes to my mind of a matter where I lost. Identical.
But similarly, I lost in one of the matter where my
So bring that.
Identification is not a problem.
Bring that. Because it readily comes to my mind where I lost. Similar thing. One of the boundaries was wrong. I'm telling you. So you will be in difficulty. One of the boundaries, and you may not have to travel very far. It's within the High Court's original site jurisdiction, I'm telling you. The property falls within High Court's original site jurisdiction also.
But in this case, it has a premises number which is identifiable. I would say, the dotted boundary is a super.
Which paragraph?
Kindly takes up. Paragraph 31, 29 to 31, that the power of the executing court has been held, it can do it, where identification is not a problem. And my lord, this was held to be a correction under paragraph 26 also. Then it has been held, it's a correction in nature since it's not a identity is not a problem. It would be taken into a nature of 1 for 52 or in exercise of 47. This can be done. কি করে বাড়াবো?
What is the defect?
The defect is not the schedule, in the schedule.
Yes, here the not has been said Kaluram Sharma. Yes, so what is the change you want? দিন তো সব কেউ আর কাগজ ফাগজ রাখবে না, সব এর মধ্যে।
Takes up the plaint. My lord will find
Plaint I have.
Yes.
Where is
Now,
the corrections you want?
my lord will find in the plain, my lord, not Kaluram. So before Kaluram, there is a shop room. My lord, that shop room should be there instead of Kaluram.
After the what Kaluram Sharma, shop room.
Yes. My lord, Kaluram Sharma, before that there should be a shop. And my lord, similar.
Kaluram Sharma shop room.
Yes.
So it's the shop room of Kaluram Sharma.
So Kaluram, it should be a shop. Otherwise, premises number 201, bailiff reaches in 201. There is no problem, and court says bailiff has found resistance on 201. But as bailiff has not pointed out, so court is refusing. That's the impugned order.
You are trying to take possession of a different property, Mr. Chatterjee.
201, because my scheduled premises
Which is not the
201.
decretal property.
This is the decretal property.
এই 94 আছে তো একটা।
94
Past. Oh.
114 is there with him.
May I please your lordship?
108. 110.
Yes.
108 একটা ছিল।
Indicate, my lord, a very short matter, my lord, squarely on the ground that 227 we have preferred for the reason that the learned single judge junior division at Purulia entertained a suit valued at the subject matter of the suit is 3 crores rupees. First,
Civil Judge Junior Division.
Civil Judge Junior Division. My lord, kindly allow me to put the 3 broad points. Why 227 we have filed? 3 crore subject matter entertained.
What do we want here?
My lord, stay of the operation because a national highway project
Stay
has
of
been
the operation of what?
the impugned order by which injunction has been granted.
That cannot be done.
Yes, my lord, it can be. My lord, kindly hear me for 2 minutes.
Injunction, please prefer an appeal.
No, my lord, kindly. In case of complete lack of inherent jurisdiction, I am fortified with our bench, our High Court's coordinate bench, division bench judgment, which clearly says that inherent jurisdiction 227 can be entertained, my lord. Kindly see the plain. Just bear with me for 2 minutes, and thereafter, if my lord is not satisfied, my lord.
Which court's judgment?
Our Honorable High Court, my lord.
Supreme Court have you brought?
Supreme Court, I am fortified with other Supreme Courts as well. My lord, allow me to
Injunction order bypassing the appellate remedy directly to 27.
My lord,
2019, I think 9 or 10 Supreme Court
My lord,
cases.
227
Authored
is-
by Justice Nariman. Please bring that, give me that. Says near absolute total bar.
My lord,
That's the language used.
my lord, may I just say this thing? My lord? In Surya Devi and thereafter in
Surya
Sadhi
Devi has
Sharma,
been distinguished
in
thereafter
distinguished-
in Radhakrishnan.
But my lord, kindly appreciate this thing, my lord. A civil judge junior division entertaining a suit for 3 crore rupees. Secondly, granting an injunction in a infrastructure suit which is otherwise barred under specific relief act that the court could not have entertained. 3
What
grounds.
prevents you from going to the appellate court?
My lord, during the time when we have preferred this 227 application, my lord, at that particular point of time, there was a bar resolution in district judge at Purulia. Now, my lord, there
But
has been-
now it is over.
now the
So at that point
but-
of time, if you have moved, it was fine. But
my
now,
lord, means our bad luck that we couldn't pursue and move the matter before that. But my lord, kindly see the illegality. And this is a typical case where, my lord, the 227 power should sparingly be used. Because, my lord, kindly see, a 3 crore suit that a learned single judge will not see. The subject matter of the value is 3 crore. It's an infrastructure project which is clearly
show me
barred.
the plaint.
Yes, my lord, kindly. Page 38. Page 38, page 39 is this is the declaration he is giving. 100 rupees declaration, injunction, consequential relief. Now, my lord, kindly see that before taking forward, my lord, kindly see the paragraph number 5 at page 40 clearly says National Highway Project. No section 80 notice even granted. The court ignores that. Directs NHAI, please do not disburse the payments. There is no prayer for seeking the leave even. And now, my lord, kindly see the page 44 are the prayers. What decree he is asking for? A decree of declaration that the defendant has committed breach by not paying.
What is the
3 crore.
judgment you are referring to?
Well-
Because maintainability, sir, I'm
My lord,
very-
allow me, just bear with me for 2 minutes. I'll take you through the judgments, my lord. My lord, first, if my lord is not
No,
keen
please,
towards.
please, I'm on the maintainability issue first. Please show me that a 227 is maintainable.
My lord,
Before
allow me
entering
to
into the
place
merits,
Surya Devi once.
you have to show the decision which has distinguished.
My lord,
Surya.
2019.
Surya Devi is on powers of the High Court under 226 and 227.
Correct, correct.
So those paragraphs says writ of
Well-
certiorari and supervisory jurisdiction. It says what is the scope. It does not say for a moment that an appellate order, you can bypass the appellate remedy and directly come to the
My lord, there are
Please show me that.
judgments. There are otherwise, my lord, our coordinate bench judgments, my lord.
This
This
is
is not
not
here
an authority.
an absolute bar.
This is not an authority for the proposition that you can bypass an appellate remedy, come directly
It
to
is
the.
not an absolute bar in case if there is inherent lack of jurisdiction. Allow me, my lord.
That
My lord.
if an appeal lies, you can directly come here.
My lord, kindly see para 24 from placitum. Though the power, though the power is akin to an ordinary court of appeal.
Paragraph.
Para 24 placitum E.
Yes.
The 3 lines, my lord, starting. Though the power is akin to that of an ordinary court of appeal, yet the power under 227 is intended to be used primarily and only in appropriate cases for the purpose of keeping the subordinate courts and tribunal within the bounds of their authority and not for correcting mere errors. The power may be exercised in cases occasion grave injustice or failure of justice, such as when, number 1, the court or tribunal has assumed jurisdiction which it does not have. 2, has failed to exercise jurisdiction which it does have, such failure occasioning a failure of justice. 3, the jurisdiction, though available, is being exercised in a manner which tantamounts to overstepping the limits of jurisdiction. Well, this is a classical case where the learned single judge ought to have seen not only the value, he himself records in the order. Otherwise, I am not going whether there is any prima facie finding or not. Those are the subject matter of appeal. What I am on is when you are trying a suit, you have to see the subject matter. Well, kindly allow me to place this Manthan 2005 to CHN 648 once. Yes. Just give one. Well, paragraph 7.
17.
Once. Specifically. May I just say? Therefore,
so this is the first miscellaneous appeal.
I know, my lord. Just the proposition, my lord. Kindly up.
This is the first miscellaneous appeal, sir.
Very well, my lord. It is 227 is
because when I went to the quorum, it struck me because the proposition which you was citing, that is why it struck me. The first line of that judgment, then I found how it is distinguishable.
My lord, it is first miscellaneous. But my lord, the proposition.
First miscellaneous appeal, you can go. I'm saying that you approach the appellate court.
My lord, kindly see in 227, our High Court. From and para 25 onwards, my lord. After considering the rival contention, my lord, I am relying upon 227 this judgment. After considering the rival contention of the parties and upon perusal of the materials on record, this court at the outset reiterate that
which paragraph you are
25, my lord, this one. Our High Court in a civil revision. This is a revision that was entertained from an order of National Property Law.
NCLT, not the civil suit.
Sorry, I stand correct. Civil.
Not a civil suit.
Just give me one moment. Well, this is from a civil suit. Yes, my lord. Kindly see paragraph 7.
Then how did it go to NCLT?
No. NCLT, I stand corrected. That is the other judge. Para 7. My lord, the relevant portion is starting from para 25. May I please? After considering the rival contention of the parties and upon perusal of the materials on record, this court at the outset reiterates the settled law in exercising.
Mr. Chatterjee, 2019 9 SCC, I think. Justice, what is the citation? What is the citation? 2019 judgment. Please search it out because there I tell you. Then that is not that. The Costatl is also because I have considered that judgment, and the councils, most of the councils who appeared here also appeared before me in that proceedings in 227. So there is a judgment which says Justice Nariman distinguished between appellate. You will be finding in several statutes that there's an appellate remedy, or there is an availability of an appellate remedy or any other remedy. 226 and 220. What is the volume? This is that near absolute total bar. Mr. Banerjee, where it says which paragraph near absolute total bar? Please, have you got that? No, not that. I think there's another. I'm also forgetting that Costatl where शायद बाबू नहीं ना. Yes. So the proposition there, the Honorable Supreme Court, that judgment which you are finding, no, they are, I think 2019 9 SCC or so, I think. No, not this judgment. No, the proposition, yes, 2019. Yes, 9. I told you 2019 9 SCC 5. I think that 2019 9, but the page I have forgotten. Near absolute total bar. That's the exact language which has been used. My memory is betraying me. Pages. You have got that?
Yes.
Justice Nariman's judgment.
I haven't read it. She just
Yes. Mental, yes, I think this is the judgment. Yes, but courts should always bear in mind a distinction between the cases where such alternative remedy is available before civil courts in terms of the provisions of the Code of Civil Procedure, and number 2, cases where such alternative remedy is available under special enactments and or statutory rules, and the fora provided therein happen to be quasi-judicial authorities and tribunals. In respect of cases falling under the first category, that is civil courts and those which may involve suits and other proceedings before civil courts, the availability of an alternate appellate remedy in terms of the provisions of CPC may have to be construed as a near total bar. Otherwise, there's a danger that someone may challenge in a revision under Article 227, even a decree passed in a suit on the same ground on which respondent numbers 1 and 2 invoke the jurisdiction of the High Court. This is why a three-member bench of this court, while overruling the decision in Surjai V. Rai, which you are referring to, versus Ramchandra Rai, pointed out in Radhesham versus Chobinath that orders of civil court stand on a different footing from orders of the authorities or tribunals or courts other than judicial or civil courts. It's on a different footing. So here, when there is a procedure, provision under the Civil Procedure Code, 227 will.
My lord, with deepest of respect, kindly hear me now. My lord, with deepest of respect, this particular judgment says.
Yes, Tuticorin Education Society. That name was not coming in my mind. Tuticorin Education Society. Yes.
This judgment clearly says that when a 227 should not be entertained when an alternative remedy or the correct remedy of the appeal. My lord, kindly appreciate one thing. I am not on merit of the matter. I am not challenging the merit of the order.
Maintainability. Sir, maintainability. You have a forum.
Kindly appreciate this thing, my lord. I am not challenging that whether there was prima facie finding, whether the judge felt that
Sir,
the balance of convenience.
I appreciate that, but you are on the threshold. Why you should not be relegated to the recourses available under the Code of Civil Procedure Code?
It's not a with the best of respect.
Sir, you are citing a coordinate bench. I am a Supreme Court, and I have delivered.
I'm not.
I am delivered.
Then, in that event, allow me to come back, consider my lord's judgment, and come back. Allow me to come back, consider judgment on this point.
This is relying on this. This judgment itself, Tuticorin Educational Society is clear on this.
But my lord, with deepest of respect, I haven't gone through it, but the only.
This is the paragraph you can go through this. This says, see, what is the distinction is between two.
Which one?
2019, Volume 4, SCC 2143 of the Supreme Court.
Would be maintained. On Monday. I'll consider this thing because I'm armed with another Supreme Court, my lord, which clearly says that it can be done. Allow me to come back because I don't want to show it from mobile and this thing. Allow me to consider this judgment. Fix it on
227 in a civil proceedings can be done bypassing the appellate remedy. That is the thing which you have to show that.
But my lord has to
against an order.
One small thing, my lord has to appreciate. I am coming at this threshold, my lord.
I am on the threshold. I am not going into the merits. Sir, only one thing. You are challenging an order of injunction. You are challenging an order of injunction.
Three grounds. One is that the specific.
First thing is that you can whether you can challenge an order of injunction directly under 227 or you have to go before the civil.
In order to challenge the maintainability of the suit or that the suit has been entertained. And it is the order has been passed completely without jurisdiction. I have to challenge the first order through which the injunction.
What are the exceptions? I am asking you. What are the exceptions where 226 and 227 can be entertained even if there is an statutory remedy available? These are the exceptions which you are telling. These are the exceptions without jurisdiction, not considering. So there, this Tuticorin, it has been considered. In other cases, yes. You can come. Civil proceedings, civil courts, CPC remedies, you cannot.
Well,
that's the distinction.
Allow me to come back on Monday, my lord. Monday, my lord. Anytime, kindly fix it on Monday.
The petitioner has
May I, your lordship, will kindly please?
Yes, sir. Please take back this judgment. Yes, call the next
Sir.
matter.
My lord,
106, sir. If you allow the motion, sir.
106.
Yes, sir. AD 106, sir. Tejesh Bull versus.
Please wait because one monthly list matter has been mentioned. Mr. Banerjee, yours is any mention? Please wait because one mentioned.
By other side, Mr. Shakti is not there. But I am only apprehensive if the matter goes down.
On that ground, it was adjourned because one learned advocate prayed that it has to be adjourned. I recorded and your junior is saying that he wants to. Let me see what can be.
I've been waiting for this matter since morning. No difficulty, Mr. Shane has not come today.
Let me see because some two matters, I think monthly two matters have been mentioned.
112 cannot be taken up because the other side is not here. So if the matter maybe clearly at the top on Monday.
It will be appear in the same position. Monday. Monday, many matters have been disposed of, Mr. Banerjee of this.
My lord has
That will be.
Mr. Shane exhaustively. I was in the midst of the
Yes, let me see what will be the position, then I will consider.
may I, your lordship, your lordship.
কোথায় এখানে ও অলরাইট তাহলে 114 you are appearing.
May I?
114 114 yes.
Before your lordship, the matters get taken up. It is extremely desperation. Out of desperation, your lordship, I mentioned, can item number 80 be taken up? Expeditious disposal. Petitioner is an advocate, your lordship, who is constantly being defrauded by the clients. For 6 years, matters not heard. 80, your lordship.
Strategy, you are appearing.
No, no, no.
Please wait, let me
Grateful,
see.
grateful.
109 item number
89.
109.
100 and where were you when these other matters were mentioned? 109 টা একটু এ করে রাখুন না মান্থলি লিস্টে পরে ডাকবেন 109 টা নোট করে রাখুন মান্থলি লিস্টে ডাকার পর তারপর ডাকবেন yes 114
there was a direction to service but my lord my learned friend
who is appearing for the other side strategy
I have not mentioned that's why my lord I know today is the problem my
we are suffering an injunction order and there is also stay.
Oh, both sides are here.
Yes. No, my lord, one of the party who was sought to be added, court allowed
how
that.
can taken up today, sir? All the parties, you have taken a resolution. You have taken a resolution not to pass any adverse order. What can be done? Don't put the court into embarrassment. Yes, এটা নয়. Yes, monthly list রাখুন.
Little higher. So that we are suffering an injunction.
হ্যাঁ, ওই একদম ইন্ডিয়া হাইকোর্টের ক্যালকাটার উপর দিয়ে দেবেন.
Any order path today? Any order path?
It will help you with the challenge.
Could help you.
Yes, yes. What do you want?
What my lord does, first my lord take the time my lord order sheet my lord gives learning with this. That my lord take issue the summon to it. My lord the 21 January.
What is the order which you are challenging?
My lord I have to challenge the order my lord take the time my lord the last
22nd January 2026.
Yes, my lord take the last paragraph my lord the petition dated 27 January 2025 was rejected on by the order number.
Where is the order dated 27th of August?
There is the detail. The 17th November for argument. Instead of summon to witness.
Please give me a minute. Please give me a minute. Where is your application under section 152?
Kindly, my lord, please advance. Page, my lord. Kindly, my lord, page, my lord, 30, my lord, 30.
Page
30, 30,
32?
30, 30.
Oh, 30. Yes, what is the submission?
Then, my lord, please, my lord, first, my lord, that issue summon to witness. My lord, this, my lord, next day, my lord, going to summon witness, my lord, appear. And the application to the recalling this order. My lord, this, my lord, the kind, my lord, my lord, page, my lord.
No, 27th of February 2025. What happened?
This, my lord, rejected the recalling application and
No, 27th of August, your application dated 27th of February was rejected.
Not my, I am the plaintiff, my lord, defendant, my lord,
No, 27th of February 2025 application was rejected.
rejected and my lord, argument instead
Yes.
of summon to witness.
Why?
Well, this is
How do you say so?
well, kindly, my lord, page 21, my lord, this order of sub.
No, maybe you have filed the application, court has rejected that.
No, my lord, no,
Is,
this is
yes,
one
yes,
of
the entire reading of the order says, in reply, the order submitted the prayer can be placed on the consider the submissions, peruse the case record, peruse the evidence. It appears that the instant prayer is to fill up the lacuna in evidence. The necessity of calling during the is rejected. No.
No, my lord, no, kindly, my lord,
After it is rejected, how can it be done?
no, my lord, not my application rejected. My lord, rejected, my lord, defendant's application.
Where is the application dated 27th of February 2025?
27.
February 2025.
Kindly, my lord, page 25, my lord.
25,
my lord.
To recall the order dated 21st of January.
Yes, these kindly, my
The order dated 21st of January.
kindly, my lord, order sheet, my lord, order sheet, my lord.
Yes.
This is the matter to summon to witness. My lord, this is the matter. The today's the date fixed for further cross examination PW2. At the first chance, the PW defendant DW will
Yes, so the defendant
and summon to witness.
No, defendant has filed this application for recalling of that order.
Yes.
Yes, that
this
was
application was rejected and learned court below the fixed for argument instead of summon to witness. Summon to witness will be appeared. If the application this order 21st January the survive.
the petitioner, the learned advocate for
So item number
9.
My lord, hi.
These matters will come up on Monday. No difficulty.
But I am for the petition, but I'm led by Ms. Ghosh, who is appearing online.
Yes, who is appearing?
My lord, I am appearing for the petitioner. My lord, can it be taken up today?
Yes, what is this matter?
My lord, this is an application for speedy disposal. The matter is pending before the Land Reforms Tribunal. My lord, the
How
difficult.
Land Reforms and Tenancy Tribunal, if that is there, you have to approach the division bench. How can it be before the single bench? Cannot be before the single bench.
Then, my lord, I am not pressing the application.
I give you liberty to file an application before the division bench.
I am grateful, my lord.
The learned advocate.
My lord, kindly permit me to hear the order.
Number 80, Your Lordship, kindly, Your Lordship. Expeditious, 80.
80.
Expeditious
77.
disposal, I will take Your Lordship's 3 minutes. That's it.
80 ta dakhun.
77, Lordship. Kindly 77 item.
8106.
80 ta dakhun. You should have mentioned it earlier. It should have been.
I'm aware. I'm sorry, Your Lordship. In the meantime, I'll give just a background, Your Lordship. The petitioner is the advocate, Your Lordship. The defendants are the client who has defrauded and taken the advocate for a ride. Since 2010, Your Lordship, I think the only mistake of the advocate was to continue to provide his services. And the defendants did not pay his bills of worth rupees 40 lakhs. He is a practicing solicitor. He had to sell his 200 square feet office in Old Post Office Street just to meet his ends. Now, Your Lordship, the suit is filed in 2021. Your Lordship, Your Lordship would be surprised to see the audacious nature of the defendant. Your Lordship, I'm protected by an ex parte ad interim order of injunction where his properties were attached, equivalent to my amount of claim. Your Lordship,
What is the stage of the suit?
Your Lordship, stage of the suit is more pathetic. Injunction application filed in 2021, still pending. That
Injunction application is pending.
It is for past 6 years. Now, Your Lordship, I am protected by an ex parte ad interim order. Despite so, the defendant.
What is the miscase for?
Miscase is for, Your Lordship, disobedience of that ex parte ad interim order, because despite an injunction, he went ahead and sold his properties because he doesn't care about the court's orders, Your Lordship. So that's why we were coerced to file an order, say Order 29 Rule 2A. That is still pending. Now, Your Lordship, today this person is willing to recover his money. When will he recover, Your Lordship? For the last 6 years, what they are doing, Your Lordship, they are coming, making the plaintiff advocates wait till the end of the day in the name that their senior would come. Your Lordship, the court doesn't have a fault. The court is also waiting and giving her next time. And I will show Your Lordship one order which is extremely has to be heard out fully for disposal.
Injunction application is pending.
Pending.
Next date fixed for hearing of the
13th August 2026, Your Lordship.
14th of August.
Page number 161.
161.
Yes. Last matter taken up on 15/5/2026. PO is on leave. And now we have
under Article 227 of the Constitution.
Six, sir.
106,
Yes.
106 था तीन तो.
Grateful, your lordship.
106.
So I'm in a person over here as an applicant, and in the lower court also I am appearing in person, sir. I'm the defendant, the tenant, sir. Now, sir, this suit has been filed on the 20th of September 2024, and the suit.
What is the order which you are challenging?
Sir, the order dated 25th June 2026, sir. In this order, sir, this is about insufficient period allowed in the notice. According to Section 6(4) of the Tenancy Act.
You are the defendant.
Yes, I'm the defendant, sir. Now, sir, the Section 6(4) is very explicit. It says that 1 month of notice that has to expire with a tenancy month. Now, sir, the notice that the plaintiff has given, that is on page number 18. So the notice that he has given, sir, if you just turn to page number 90.
You have taken that point in the written statement.
Sir,
have you taken that point in the written statement?
I have not taken the point.
Why have you not taken that point in the written statement?
So
how can that be decided here?
So what has happened in this situation? What happened is that I had a learned advocate representing my matter, but somehow, sir, he just misled, or he just compromised the whole thing, and I was not even informed that I have to make the rent deposit with the learned court. So after I received the Section 7(3), the defense was struck out. Then I'm appearing.
Where is your application under Section 6(4)?
Sir, the application is on page number. Sir, page number 28, sir. Page number 28, the application is under Section 6(4). What I've said, sir, is that the notice was received on the 31st of July, and the notice allowed.
What is the written statement? Where is the written statement?
So the written statement is with me, sir. I will give.
Please give me the written statement.
The learned advocate who was.
Please give me a minute. Yes.
So the learned advocate who was representing me, he somehow just, sir, he just.
I cannot go into that here. This is a 6(4) application you have filed. That will be an issue in the suit, rightly held by the learned trial judge. Rightly held by the learned trial judge. You get that opportunity. Fight it out in the suit. In the suit, it raises all points.
So, but the suit cannot be instituted.
No.
If the notice.
That will be dismissed. That will be dismissed. Cannot be decided at this stage.
minutes, Your Lordship.
DB.
Expeditious disposal, Your Lordship, kind. Yes, it will take 2 minutes, Your Lordship. Kindly, Your Lordship.
Yes.